just wait and let everyone get settled. Yeah. All right. Okay. I'm going to let you pronounce your name because I'm probably going to mess it up.
Good morning. May it please the court. Endel Kolde for Richard Lowery. Professor Lowery is an independent thinker who would like to go back to sharing his opinions about what is really going on inside the campus bubble at UT Austin. In better days, he tweeted at elected officials and others about lack of viewpoint diversity, land acknowledgments, and what happened to the Liberty Institute project. That was bad enough, but what really bothered the tower was when his speech threatened the flow of dollars to the university. When Lowery called out UT's president on a podcast, that crossed a line. The word came down from the tower that Lowery's speech needed, quote, review and handling as a personnel matter. Within days, Deans Mills and Burris met with Carlos Carvalho about Lowery's speech. Everyone agrees the meeting occurred. Everyone agrees the deans wanted to get Lowery to speak differently or not at all on certain topics. And everyone agrees that the deans achieved their goal. Lowery stopped speaking not long after the Carvalho meeting took place. To us, this is essentially res ipsa loquitur. It's either First Amendment retaliation or illegally chilling speech. We ask this court to join the majority of circuits in explicitly recognizing that for a Section 1983 First Amendment retaliation claim by a public employee, the appropriate standard for deciding whether a public employer's actions were sufficiently adverse is that a reasonable employee would have been dissuaded from engaging in the First Amendment protected activity. We ask that this court hold that Burlington Northern implicitly overruled Bro, because Bro, like this court's now overruled Title VII retaliation decision in Mattern versus Eastman Kodak, rests on a mistaken, judge-made limitation of retaliation actions to ultimate or completed employment decisions. In Burlington Northern, the Supreme Court held that no such limitation exists in the text of Title VII, overruling this court's holdings to the contrary in a situation that is analogous to First Amendment retaliation. As with Title VII, no such limitation exists in the text of 42 U.S.C. 1983, which of course provides for relief against state officials who deprive any citizen of their constitutional rights, including the right to free speech. Notably, it does not single out public employees for different treatment than citizens or limit what employer actions may be considered retaliation. Beyond lacking textual fidelity, Bro, in our view, defies common sense. As the Supreme Court recognized in Burlington Northern, the point of retaliation protection is to encourage employees to exercise their rights free from fear. If one sets an artificial limit, employers will, of course, go right up to that limit to pressure employees, as this case demonstrates. Bro even recognizes that its judge-made limitation will lead to the chilling of speech, but it then characterizes the violation of constitutional rights as a relatively trivial matter. We would submit that a violation of First Amendment rights is never a trivial matter, and in holding to the contrary, Bro rests on a faulty premise. Burlington Northern also changed the focus of the retaliation inquiry. Anti-retaliation protection, quote, it seeks to prevent harm to individuals based on what they do, end quote. In this case, exercise their First Amendment rights to speak and criticize a government institution. So we now ask this court to close the Bro v. Garland loophole, which allows employers to censor employees through threats, and find that Bro was implicitly overruled by the Supreme Court in Burlington Northern. In the alternative, we ask this court to recognize a related claim of chilled speech based on Keenan versus Tejeda, or an implicit policy of speech suppression based on Jackson versus Walker. We would submit that the Keenan standard is particularly appropriate for this case because it was originally proposed by UT and adopted by the district court before UT later came back and disavowed the Keenan standard. In its response brief, UT's counsel actually claimed that they never disavowed the Keenan standard, which is flatly contradicted by the record. UT's unorthodox approach to litigating this issue has earned them the application of the Keenan standard by way of judicial estoppel. Alternatively, we'd ask this court to recognize that there is such a thing as a chilled speech claim that is distinct from First Amendment retaliation, along the lines of the implicit policy at issue in Jackson v. Wright. We would also ask this court to revive Lowery's challenge to UT's unwritten civility code, which we assert is only applied to conservatives like Professor Lowery, but not to left-wing academics who also post provocative opinions on X but don't get counseled or threatened about their speech. This last count is essentially a pre-enforcement challenge. Lowery has been threatened with enforcement of this unwritten code. Just to summarize briefly the evidence of that, which the other side has claimed was lacking, his dean categorized his speech as offensive, factually inaccurate, unmannerly, and lacking in civility. His department head called his speech rude and unacceptable. His associate dean expressed the opinion that his tweets, Lowery's tweets, needed to be more civil in tone. UT claims we didn't allege any facts in our First Amendment complaint, but in paragraph 122 of that document, it's going to be AROA 273 through 37, we describe how left-wing faculty are allowed to tweet about some topics that Lowery wants to discuss, but from a different perspective. Some of them use colorful language like fascist or racist or other terms, and yet faculty expressing those views aren't talked to or asked to tone down their tweets or placed under police surveillance for a threat mitigation investigation or anything like that. That should be enough to state a claim, and the threats to Lowery's Salem Center affiliation should be enough to establish standing.
You're still, though, pursuing a retaliation claim, even though you say that chill speech is separate from retaliation.
Yes, and I mean, the reason we're alleging those other claims is because of, the retaliation claim was dismissed, and there is the question about the borough limitation on the retaliation claim. We'd like to...
Focusing on the retaliation claim, you haven't shown an adverse employment action, is that right?
Well, our view is we have shown an adverse employment action, but of course the court below found that borough was still good law and applied the borough standard. Judge Ezra, to his credit, acknowledged that there was room for clarification and was hoping that there would be clarification from the Fifth Circuit on that. We've cited in our briefs a number of other district courts in this circuit that have found that this court found that Burlington Northern was implicitly overruled, that Burlington Northern implicitly overruled the borough standard.
And it'd be cleaner if we were to agree with that we would go in bank just to clarify that borough is no longer good law.
That would be cleaner, Your Honor, yes, and that would be our preference. We would prefer to pursue a straightforward First Amendment retaliation claim like we would be able to do in basically any other circuit in this country, because like in Burlington Northern, employers are very good at figuring out what they can do to get what they need to do to get their employees to do what they want or not do what they want, which is in this case engage in whistleblowing activity or say things that might be embarrassing to the CEO. To regular people, threats are a very effective way to get them to shut up. And they knew exactly how to get to Lowery here. They went to talk to his friend and colleague, and yes, the director of the Salem Center, and they attacked his, or essentially threatened his, affiliation with the Salem Center, which is not subject to the tenure protections that his underlying job would be. It would be much harder for them to pursue disciplinary action, beyond removing his Salem Center affiliation, although that would be a possibility too. Just to wrap up, Your Honor, since I don't have a lot of time, we briefly want to discuss the discovery issues that we also appealed. On the hard sell text string and the PR talking points, we're asking for a quick second look. For over a half a year, they told us that Jay Hartzell never texted Dean Mills or Burris about Lowery in the summer of 2022. They delayed the disclosure to the last possible moment and tried to bury it on a privilege log. The context makes us skeptical that this is truly privileged, or at least privileged in full. Mixed business and legal communications are not presumptively privileged. At best, they are subject to redaction and partial disclosure. The magistrate judge never explained his reasoning, and neither did the district court in reviewing that ruling. On the nepotism discovery, I would just say that there is no privacy right for public officials to cover up their misuse of state resources. The baseline test for the scope of discovery is that it has to be related to a claim or defense. UT has opened the door to this issue, and it had opened the door to this issue very early in this case by arguing that Lowery's statements about Jay Hartzell's honesty are factually inaccurate or defamatory. Well, one reason Lowery thinks Hartzell is a liar is that he's a hypocrite. He wants DEI for everyone else and their kids, but not for his own family. That's Lowery's view, that's his opinion. If the allegations are true, which we were blocked from discovering, this would be a paradigmatic, good example of unearned privilege and support Lowery's opinions about Hartzell. We'd ask for this court to reverse the district court on the merits and remand this case for further discovery. If the court does not have further questions at this time, I'd reserve the remainder for rebuttal.
Yes, you saved time for rebuttal. Thank you, Mr. Kolde. Mr. Oldham?
Good morning. May it please the court. Jeff Oldham on behalf of the defendant UT officials. The fundamental problem with Professor Lowery's case is that none of his claims can survive dismissal under any of the recognized standards for assessing the employment actions that were allegedly taken against him. That simple conclusion is reason alone for this court to affirm. Whatever this court may think of the substance of Professor Lowery's speech in this case, if First Amendment retaliation-based claims are available for the sort of allegations here of indirect attempted counseling, mere criticisms, and allegedly perceived yet then disavowed oral threats, that will make it incredibly difficult to run a university or another public agency. Litigation and discovery will be recurring tools for fighting campus disagreements and other conflicts. And federal.
Are you saying there were no threats, or the threats were withdrawn, or what? Just tell me what UT says about whether there were threats.
Well, of course, we dispute the allegations. Some of the claims, as they come to this court, are on 12b-6, and so we have to take those allegations as true from the complaint. The chilled speech, and that is the First Amendment retaliation claim, and then the unwritten speech code claim. Those are here on 12b-6. The chilled speech claim also was resolved on summary judgment. So on that claim, we actually have evidence in the record. So I want to make that clear so the court understands the different burdens. But looking just at the allegations alone, of course, again, we dispute those, and we dispute that there were threats, but Professor Lowery has alleged that he was threatened. But from the complaint alone, it's clear that defendant Burris disavowed the threat in their second meeting in August. And so that disavowal is in the record. In addition, or is in the complaint. In addition, what's also in the complaint is that weeks after the August 12th meeting that Professor Lowery complains the most about, he was then reappointed to the Salem Center position that he claimed he was threatened about. He
got a raise.
So he got a raise in his UT tenured position. Just to be clear, that is in the summary judgment record, not in the complaint itself. But yes, that is in the summary judgment record. Also in the summary judgment record, if we're looking at the chilled speech claim, or if we're talking about whether Professor Lowery even has standing, he was reappointed not just weeks later in 2022, he was reappointed to the same position a year later in 2023. In addition, he was given a pay raise not only in 2022 for his UT tenure position, but again in 2023. And once more, if we're talking about standing, or we're talking about summary judgment and looking at the record is replete with disavowals, express disavowals from defendant Mills, defendant Burris, and others in declarations, sworn affidavits in the court, and also deposition testimony where they have said that they never threatened, that there was never intended to be a threat, that they don't currently threaten and have no plans to take any action against him. So if you look at the whole record of what's in before the court on the summary judgment and standing, you have a situation where any threats that were perceived have been thoroughly disavowed, and Professor Lowery just simply refuses to take yes for an answer and is continuing with this litigation anyway. On the First Amendment retaliation-based claim, again, which goes to what's in the complaint, there too you can see that the any perceived threat was disavowed. And I want to just go back to the fact that I know Professor Lowery has teed up this issue for you all to consider about whether or not Bro or Burlington Northern is the right standard. But the easiest path for this court to resolve this case is to recognize that Professor Lowery loses under either standard. He makes no serious argument that he can prevail under this court's Bro and in the cases that came before it and after it. As to the Burlington Northern standard, again, that standard in the Title VII context asks whether they're an objectively reasonable employee in the context of the case would have found the challenged actions materially adverse such that the actions would have dissuaded the employee from making a Title VII discrimination claim. And the U.S. Supreme Court in Burlington Northern was very clear about the importance of the materiality threshold to avoid certain claims that are trivial from coming into court. Or, in trivial is not to trivialize the speech, just to be clear. It's to trivialize what responsive actions were taken by the government employers. And then second, that the objectively reasonable standard is key. And all we're talking about here, to go back to just the 12b6 record, all we're talking about is that there was no dispute whatsoever to Professor Lowery's UT tenured position. As to the Salem Center position, according to the allegations, Burris and Mills approached Carvalho about counseling Professor Lowery about his speech. Carvalho refused, so even the counseling went no further to Professor Lowery directly. It's also undisputed, again, that Burris disavowed any threat, saying it shouldn't be interpreted that way. And then just a few weeks after that August 12th meeting, I've said it before, but Burris was reappointed to the Salem Center. If that type of indirect counseling about the university impact on an employee's speech is enough to be actionable in federal court, to be able to file a federal lawsuit, obtain discovery, it's incredibly difficult to see how a government employer can run a university or run a public agency. And that's what this court's precedent fully recognizes in Bro and going backwards in Coulson and other cases, is that in the employment context in particular, you have legitimate interests on both sides of the ledger. You have not only the free speech of the plaintiff at play, you also have on the other side of the ledger free speech claims by other employees, which here you see that, and free speech claims by other employees who raise concerns. And then you also have the government's legitimate interest in running a university, being able to talk to its employees about matters. And it's in this sense, it's a two-way street. Professor Lowery absolutely has a right to speak freely, but at the same time, the government has a right to, at least as an employer, have the conversation about productive ways to, in this case, for example, managing having multiple institutes within the University of Texas and having a productive or at least a neutral relationship. And so this court's case law is spot on in understanding the need for that leeway for employers, and so too does the Burlington Northern Standard. Again, we think that Professor Lowery's claims are easily dismissed under that standard as well, because no reasonable person in Professor Lowery's position, based on everything that had happened, would have chilled his speech out of the fear of losing his secondary Salem Center position or any of the other threats. And again, if any other conclusion would simply incentivize more federal lawsuits and turn litigation and discovery into a tool for having courts micromanage the way that universities and public agencies operate. And so in terms of just resolving this case, the court can simply hold, as the court in the Bell case that we cited in our briefs, the 11th Circuit said, is that there's no reason to resolve which standard applies when the claim fails under either standard, and that is exactly this case. If the court were to apply Burlington Northern, just to be clear in this analysis, there's many of the cases that are cited in the briefs strongly support our position here that a mere threat of this nature is not enough to give rise to a materially adverse action. And I would point the court to this court's own case in Brandon against Sage Corp., which is a Title VII case, where the court there recognized that a severe pay cut threat in some circumstances could potentially be actionable, but not in a circumstance where the employee heard it indirectly and would be expected to follow up on it, and that is also this case. There's other cases as well, but so under Burlington Northern or Bro, we think that Professor Lowey's claim should be dismissed. So for that reason, there's no warrant for this court to take on the issue of whether to apply Bro. If the court does ponder that question, I do though want to address quickly a couple points on that. First, we believe this panel is bound by circuit precedent. There's nothing in Burlington Northern, which is strictly about Title VII, that purported to overrule this court's or any other court's First Amendment retaliation case law, and so there's no warrant for thinking that Bro has been unequivocally overruled, which is what would be required under the rule of orderliness for this court to not follow the binding precedent in Bro and other cases. And number two, even if this court were free from circuit precedent, we think that the Bro standard is still the correct one to apply for First Amendment retaliation cases, and that's for at least two reasons. Number one, that's the best reading of the U.S. Supreme Court's current case law. As we explained in our briefs, this court's precedent under Pierce and Bro and other cases is based on the Supreme Court's decision in Rutan. And Rutan was a case in which that is still cited by the Supreme Court, including just a couple terms ago in the Houston Community College case, when the court posed the question and acknowledged the issue about how material something needs to be actionable under the First Amendment. And the court in Houston Community College again cited Rutan approvingly. And so we think that the best reading of the Supreme Court's case law on First Amendment retaliation is to adhere to this court's current precedent. And there's good reasons for that too. There are drastic differences between the First Amendment retaliation context and the Title VII retaliation context. And just to offer a few ideas on that, obviously under the First Amendment, we're dealing with a constitutional issue, whereas we're dealing with a statutory issue in Title VII. So it's one thing for the Supreme Court in Burlington Northern and other cases to interpret broadly a statute that Congress has written very broadly and give effect to Congress's policy choice on that. It's quite another matter for this court or any other court to constitutionalize a First Amendment threshold that allows so many claims to come into federal courts and leads to the situation where federal courts are micromanaging public employers. The other obvious difference between, at least one other obvious difference between the First Amendment and the Title VII is that dealing with the First Amendment retaliation context, as I said before, you're dealing with a context where there's legitimate interests on both sides. You have a free speech claim on one side of the ledger, and on the other side you have legitimate government employer interest, and you also oftentimes have other free speech concerns as well. In the Title VII context, you don't have that same mixed calculus because you have someone claiming discrimination or retaliation, and there's no legitimate interest in discriminating or retaliating against someone who makes a discrimination claim. And so we think there's good reasons not to import the Title VII test over to the First Amendment. I would like to touch on standing. We have argued standing in our briefs, and obviously that's a jurisdictional issue. And as I said before, one of the aspects of standing that is important for the court to understand is the full record is before the courts. The court can look at issues such as all the subsequent reappointments, the pay raises, and the sworn affidavits and sworn testimony of absolutely and expressly disavowing any threats from Mills and Burris and others. The other thing that is key about the standing issue is that Professor Lowery here is not seeking damages from past conduct. He is only seeking prospective relief, injunctive relief, and declaratory relief. And that is significant under the Supreme Court's standing case law because to obtain forward-looking relief, he can't just point to past conduct. He has to show a credible, substantial risk of future injury from the defendants. But here he has not done that or come close to it. All he is doing is speculating, based on the past perceived threats, that defendants would in the future refuse to reappoint him to the Salem Center or take some other action. But number one, that's pure speculation, which is not enough under Murphy and other U.S. Supreme Court case law dealing with forward-looking standing. But number two, it's bad speculation when you look at the record. Because when you look at the record, he has been given multiple reappointments and pay raises, and there's simply no evidence of any harm or of any likelihood of future harm. And so based on lack of standing, the court can dismiss all of Professor Lowery's as-applied claims, at least. He has one facial claim that he claims he has pleaded, but all of his as-applied claims can be dismissed based on lack of jurisdiction.
With he raises not just as-applied claims, the facial claim, is that the speech code, or what is that?
It's the speech code claim. His First Amendment retaliation is just as applied. His chilled speech claim is only as applied. His unwritten policy claim, he says he's alleged both as applied and facial. And this court does recognize at times a difference in the standing analysis of a facial claim versus an as-applied claim. And so that's why I drew that distinction. I will say that this court's case law that tends to draw that distinction for facial claims is because it comes in the context typically of challenging a statute, challenging a written regulation of some sort like that. And the reasoning is if it's a non-moribund statute or regulation, then we don't have to wait for, the court will have a relaxed standing standard. I think there are good reasons to treat that differently in this context, and that really bleeds into the merits of our argument about the unwritten speech policy claim here. But here, he's claiming as a standalone claim that UT has a speech policy, and we have disputed that he's alleged there is any such speech policy. This is not the usual case dealing with a speech policy or things like that, where a plaintiff sues based on actions taken, and a defendant then defends the case by saying, well, we have a policy, we followed our policy, and the dispute is over that policy. That's the typical situation where you see under unwritten speech code claims or, frankly, written speech code claims. That is not the case here. He has, as Professor Lowery's counsel mentioned earlier, read off some of the allegations that various individuals have allegedly said to him, to Professor Lowery, and his claim is taking these stray comments from these different places that he believes there's an unwritten speech code that is being followed and that exists. And we moved to dismiss that claim on the pleadings. Number one, it is nothing but a repackaged version of his First Amendment retaliation claim. After the First Amendment retaliation claim was dismissed, then Professor Lowery repackaged the same basic argument, but claimed that all the comments against him were part of an unwritten speech code. And the court should not allow that sort of end run around its First Amendment retaliation claims, because otherwise any plaintiff that fails under the First Amendment retaliation test can simply get around that by claiming that there's an unwritten speech code, and that's not enough. Professor Lowery has not cited a single case allowing a standalone claim like this against an unwritten speech code to proceed. And then just on terms of the pleadings themselves, we think that it fails under...
Well, but there's a difference, as to that, there's a difference between the standing issue and the ultimate merits. It's entirely possible that he has standing, but would ultimately not prevail if it were determined there's no such code.
That may be, and I acknowledge that bleeds very much into the merits, and again, historically this court has treated facial claims differently from the standing analysis. But I just wanted to draw that distinction that here we're not dealing with a known statute or a written statute that everyone's fighting over. In terms of the unwritten speech code claim, what the district court properly dismissed it not only because it really was just a improperly pled, repackaged First Amendment retaliation claim, but just that it fails under basic Iqbal and Twombly principles. Both because there's not sufficient allegations of actually being enforced. That's the district court's main rationale, and we agree with that. There is, for the same reason that we think there's no adverse employment action, Professor Lowery hasn't really alleged that there has been any policy enforced against him. There's been no action. There's been indirect conversations with Carvalho. There's been alleged threats according to the allegations, but there's not been any true allegations of the speech code being applied to him. And then another basis that we offered the district court, but he did not reach, was that there's just no allegation at all of of an unwritten speech code, period, and that is not sufficiently pleaded. I want to go back briefly to the chilled speech claim. Professor Lowery talked about a chilled speech claim. The district court dismissed that for very similar reasons to what I just described about the unwritten speech code claim, which is that this is nothing but a repackaged version of the First Amendment retaliation claim. And again, if a party can fail to meet the adverse employment action standard under the First Amendment retaliation and then simply say, my speech is chilled, therefore I have a First Amendment claim, then we'll see that in every single case.
You're repeating yourself, aren't you?
I'm sorry?
You're repeating yourself. You've already said that once.
Sorry. The district court, Professor Lowery relies on the Jackson v. Wright case. I think if the court looks at the Jackson case, you can easily see that that case had a much more, the professor there was banished or put on ice and literally was not allowed to work with the journal that he had helped create. So that case is readily distinguishable from here, where we're talking just about threats and other things like that. Real briefly, I would just like to close on the discovery points. We don't think that there's any abuse of discretion, and as we pointed out in our brief, Professor Lowery does not even argue that there's any prejudice, and so I'll stand on our briefs for those points in any other detail.
All right, thank you, Mr.
Thank you, Your Honor.
Mr. Kolde for rebuttal.
Thank you, Your Honor. Briefly, with regard to his reappointment and raise, that all happened after he stopped talking. He moved his account to private, he stopped tweeting, he stopped engaging in public appearances. So they got exactly what they wanted. They got him to censor himself, and he's been censoring himself throughout this case, which is why they have continued to reappoint him to the Salem Center. So that ultimately doesn't prove what they say it proves. Regarding the express disavowals, we would say nothing was expressly disavowed. This is tactical only. After we filed the lawsuit for the purposes of litigation, they're making these express disavowals. Just common sense tells one that the threats they delivered to Carlos Carvalho, knowing that he would pass them on to his friend, Richard Lowery, would chill an ordinary person. $20,000 is a lot of money to regular people. So is the loss of research opportunities if you're an academic like Professor Lowery. They knew exactly where the pain point was, and they applied it. They even admitted that their conversation with Carvalho on August 12th, a week after President Hartzell texted them, was intended to get Lowery to stop speaking. I'm quoting here from EROA 2977. This is the Ethan Burris deposition, and his testimony was affirmed by Dean Mills. My question, stated another way, your goal in asking Carvalho to counsel Lowery regarding making comments that taxpayer money was stolen by grifters, or the president is paid to be good at lying to conservative donors and politicians, was to get Lowery to stop making those kinds of comments, correct? Answer, yes. And similarly, your goal in asking Carvalho to counsel Lowery regarding making comments that were disruptive to operations was to get him to stop asking people not to donate to UT, or people to not donate to UT. Is that correct? Answer, yes. So they deliberately had this August 12th meeting in order to get Carvalho to help them to get Lowery to stop speaking. And it worked, just like they knew it worked, okay? They knew exactly what they were doing, and they delivered the message, and it was effective. Regarding the 11th Circuit case that they cited, that was a case where somebody was placed on paid leave. We would posit that that is not analogizable to our situation. Regarding the implicit overruling, we would submit to the court that if this case had been brought in pretty much any other circuit, I can't think of a different circuit, the Burlington Northern Standard would apply. And I think the case would not have been dismissed, that count would not have been dismissed on a motion to dismiss. And that's because it is a much more sensible standard when it comes to retaliation protection. With regard to the question of implicit overruling, both Title VII and Section 1983 are statutes. And specifically, the Mattern case was overruled. This court's Mattern case was overruled by the Supreme Court in Burlington Northern. In that case, this court had a standard that was very similar to Breaux. Quote, Title VII was designed to address ultimate employment decisions, which it defined as hiring, granting leave, discharging, promoting, and compensating.
I'm going to interrupt you just because you're about to run out of time. So address the standing question in regard to the assertion that you're only asking for forward-looking relief.
Well, I mean, it's no different than free speech versus Fenves, which was also a UT case, and none of the students in that case faced anything but a threat from their explicit written policy, where they also tried to control speech based on civility and lack of rudeness. And the same terminology that they're just using it orally against my client rather than having written it down. They just took their written policy and they converted it into an oral policy. Lowery has more standing than the students in those cases. Those students weren't even threatened directly. They didn't have somebody meeting with them threatening consequences. And similarly there, President Fenves disavowed an intent to enforce the policy against Lowery. So,
and then one more question. So,
yeah.
So address whether you've sufficiently alleged and raised the question of an implicit speech code.
Well, we pled the implicit speech code, and we explained what we think its terms are. We pointed specifically to the fact that we think other academics are treated differently. We gave specific examples that were cited to in our complaint and also in the record about other people, other academics making provocative tweets where they use terms like fascist or racist and all that. And we have RFA, request for admission responses, where the UT said, no, these people didn't get talked to and they weren't counseled or anything like that. So they were treated differently than Lowery. To apply the speech code, you need a finding essentially that somebody engaged in uncivil speech. We already have that because the dean has testified that she found his tweets and his speech uncivil, factually inaccurate, and disruptive. People don't use that kind of terminology when they're in an administrative position unless they're intending to send a strong message with that. Those are strong words, just like the strong words that were used in the August 12th meeting with Professor Carvalho. Talk about respect for chain of command, talk about disrupting university operations. People don't use that kind of terminology in everyday conversation. It was clearly designed to send a message. I see my time has expired, so just in wrapping up, I would just ask the panel to take a look at EROA 315 and 316. Those are Dean Mills's own notes of the August 12th conversation. She testified that she wrote those the day after the meeting, and they don't depict just a regular conversation among equals. They depict a manager and administrator sending a message that the speech is a problem, and if the speech isn't going to stop, in so many words, there'll be further action taken. Thank you, Your Honor.
Thank you, Mr. Kolde. Your case and all of today's cases are under submission, and the court is in recess until 9 o'clock tomorrow.